Good evening. I am really excited to be here. This course, we call it Civics 101, Back to the Basics, but we're going to really kind of start with the basics and go forward because we want to focus on what's at stake. And I know those of you who are on this call are really focused on this as we are, but hopefully some of the things that we talk about tonight will let you be able to share. You can share this with others. You can perhaps, find something in here that will motivate a family member, a colleague, to see why it's so important for us to elect Democrats up and down the ballot. As Kaz has said, there are three of us hosting tonight, me, Jenny Okamoto, and Kaz Margano. We are with the Building Bridges for America, an organization by volunteers, for volunteers. And I can't see the chat now that I'm talking to you all, but take the opportunity to say hello in the chat. And you'll probably make some connections with other folks in your state. We're running about at least 20 different states on the call each week. So please do that. As I said, this is Building Bridges for America. We start off with our mission, values, and vision statement, as well as a good basis in terms of where we stand as Democrats. These programs, these weekly training programs, fit really well, I think, into our vision part, because these are designed to help volunteers be informed and engaged members of the electorate. These weekly classes, that's an 8 session tranche. There are 2 civics classes. This is one of the 2. Then we have 3 grassroots organizing sessions. And then we have also 3 how to be politically active relational organizing sessions. So you've signed up for this one. If you haven't already realized, you'll get reminders to sign up for the others. In October, we'll switch the focus of these and focus more on get out the vote. So if you go through these sessions, still go through the get out the vote sessions, because they will be different enough that I think you'll get something extra out of those. We will keep people muted throughout the hour-long session. We'll have Q&A at the end, but in the meantime, put your questions and any of your info in the chat, because some of your questions can be probably answered by one of the other folks on the call, or one of our co-hosts. And then at the end, if there are still questions, we'll get to those. I'm a retired lawyer. I spent my career in and around government, and as in the private sector and in the public sector. And I've put this presentation together to, I hope, bring out some points that sometimes are overlooked, but also just really need to be emphasized as we're talking about our form of government. On the Building Bridges website, there is a workbook that goes along with this. So if you want to share this course with a group that you belong to, your local Democrat club, you can certainly do that. The slides are also there, and there'll be a recording of this session. So I'm a compulsive note taker, and if you are, just keep going. But if you don't want to take notes, you can refer back to the presentation by going online. So let's just get started. Let's talk civics. I think after the 2016 election, there was just a lot of commentary that people kind of missed the boat. They didn't know what was at stake, that we needed to know more about civics. And so here we are. We want to focus on what's at stake when we vote. What should we know? And in this presentation, we're going to divide it into 4 parts. First, talking about the U.S. Constitution and how it's been interpreted by the Supreme Court. And then we're going to shift over and review what is in the workbook, talk about federal legislation, elections, and then state and local government structure. Our workshop goals are to have knowledge that leads to action. We want to, as we said, it's our vision at Building Bridges for America that we're going to safeguard democracy by having an informed and engaged electorate. It's up to us. As Lily Tomlin, the comedian, says, I said somebody should do something about this, and then I realized I am somebody. So we are those somebodies who are going to do something about this. And we're presenting this training because if we have either a refresher or a new understanding of our system, then we'll know where to focus our efforts. Having knowledge is power, but we need to make sure our knowledge is up to date, is correct. And whether you're a super volunteer, someone who's really at the top of a campaign, whether you are a regular volunteer like most of us, and all of us are a trusted voice for our family and just an engaged citizen, this information, I hope, is useful to you. There's a lot of talk. There are many times in social media, in the news, where someone says, oh, that's unconstitutional. Can't do that. But we want to, again, start with the basics. And, if we're talking about something being unconstitutional, what can be unconstitutional? So we are going to start with the basics here. A law can be unconstitutional in itself, the way it's written, how it's interpreted, or how it's implemented. And why would a law be unconstitutional? A law, legislation, is unconstitutional if it violates a protection or a power that's in the Constitution. And who determines constitutionality? The courts, not Twitter, not Facebook, the courts. And so we're going to talk about what is in the Constitution, because you can't know if something violates the Constitution if you don't know what's in the Constitution. The Constitution is small. There are 7 articles, like 7 chapters, and 27 amendments. And they are written very simply. So it takes a lot to interpret them. But the first 3 articles, and this is from the original Constitution from 1789, the first 3 articles set up our structure of government, establishing our 3 branches of government: the legislative, the executive, and the judicial. And that's where we start, and that's where we should always end up, is thinking about that structure. And then the next of the articles, the next 4, 5, 6, 7, talk about what is the relationship between the federal government and the states. I mean, there weren't very many states back then, but it was still uppermost in the writers of the Constitution, as to what was going to be the relationship between the federal government and the states among themselves. So we have Article 4, which says that each state shall honor the other states' laws. That article also talks about how you create a new state. Article 5 talks about how the Constitution is amended, and that takes the consent of the states. Article 6 is the Supremacy Clause, and that says that the federal Constitution and federal laws take priority over state laws. And then Article 7 was how the Constitution itself would be approved by the states. So again, this is a page from our workbook, and this talks about, this just shows, but a little graphically, our three branches of government, and that there are checks and balances between each of the branches, and our vote affects each branch, and we need to figure out where we want to have our impact when something is going awry or when something's going well. And the reason that we should worry now about our Constitution, which has been there since 1789, well, there are many reasons, but the ones that I think we should focus on right now are the Project 2025, that this 900-page book put out by the Heritage Foundation that would really change that chart. It really removes some of the checks and balances and puts greater and greater authority on the president. And then there's a man named Russ Bott, who is the policy director for the RNC, and he is preparing a playbook for Trump's first 180 days if he were to be elected. And he's a believer, a supporter of what they call radical constitutionalism, which again means we're going to change the way things have been done to give more authority, more power to the president. And then, of course, the third thing that we should be worrying about is that the Supreme Court has given Trump and presidents and former presidents immunity from criminal prosecution in many cases. We're going to talk about that later. Ketanji Brown Jackson, currently Associate Justice, had talked about in a decision before she went on the Supreme Court about this constitutional scheme that is so important and really unique in the world. Our constitutional scheme is designed to prevent tyranny. Powers under our Constitution are split vertically. We call that federalism, that we have federal and state government, and powers are split up between the federal government and the state governments. And then there's this split of powers horizontally, that there's different branches of government, the legislative, executive, and judicial. And that's true at the federal level, and we can talk near the end. That's also true in all of our states. Our states adopted that type of that horizontal split, those checks and balances. And the separation of powers, the way she described it, is crucial to keep government from becoming too powerful. So after the Constitution was adopted, 2 years later, they went right back with amendments to limit the federal government's authority over individuals. So if we think about the Constitution, first it establishes the structure of our government, the three branches of government. Then the Constitution talks about the relationship between the federal government and state government. And then in the Bill of Rights, we shift over to looking at the individual and protection of the individual. And there are 10 amendments in the Bill of Rights, all designed to protect the individual in certain respects. The First Amendment, as we know, is where we are guaranteed our basic freedoms of religion, speech, press, and assembly. Second Amendment is the right to bear arms, and we can go on through. I want to talk about at the end of the Bill of Rights, there are two, I guess you could call them catch-all provisions, but the Ninth Amendment says just because a right is not listed in the Bill of Rights doesn't mean that an individual doesn't have those rights. So there is an open-ended provision there for the individual. And then the 10th Amendment says, it goes back a little bit more to talk about that balance between the federal government and the state government. And it says that if a power has not been really kept to the federal government or has not been denied to the states, then the states still have that authority. Additional amendments that we need to always have in our mind. We, of course, know the 12th Amendment established the Electoral College to officially elect the president and the vice president. And then after the Civil War, so that we're now, sort of 100 years into this, and into the country, we have 3 amendments that came after the Civil War. Because even though the Union won the Civil War, it was pretty clear that the South was not going to go along with what was was not going to abolish slavery. The South, the Southern states were not going to extend citizenship and rights to the formerly enslaved, and voting rights were not going to be extended. So these 3 amendments, the 13th, the 14th, and the 15th, are the post-civil rights, the post-Civil War amendments. And they are incredibly important today. And they have, particularly the 14th Amendment, has grown in importance since the time it was enacted. And starting after the Second World War, the Supreme Court used the 14th Amendment to extend the protections of the Bill of Rights to individuals and protect them from state action. Because before the Civil War, after the Civil War, there were contingents, of politicians, elected officials, who took the position that a state should always be able to pass laws to affect the rights of its citizens. The purpose of the 14th Amendment was to say there are limits to what a state can do. A state cannot deny equal protection. A state cannot deny due process. A state has to grant citizenship rights to those who are within its borders. The other amendment that's on this slide is the mention of the 25th Amendment, which is the amendment that provides a process when a president is unable to perform his or her duties. The very first time that we presented this program a few years ago, the question in the chat was, well, isn't there a 28th Amendment? What about the Equal Rights Amendment? Well, the Article 5 we talked about at the beginning talks about how a constitutional amendment is adopted, and that requires ratification of 3/4 of the states, which would currently be 38. And in 1972, when the Equal Rights Amendment was adopted by Congress, it was adopted with a 7-year timeline. That the actions of the states had to occur within 7 years. And within that 7-year timeline, only 35 states adopted. Now, since that time, 3 states have gone ahead and adopted, which would mean we would be at 38. So, but that doesn't count. The federal archivist is the person who accepts a constitutional amendment and says, okay, now this is part of the Constitution. And the federal archivist did not accept the ERA as an amendment after those 3 states acted. And the U.S. District Court of Appeals said the archivist is not required to accept the ERA. Now, there is legislation pending in both the House and the Senate to remove those deadlines so that the ERA would be considered to be adopted, but those actions have not been taken. And there's a resource here if you want to follow what's happening on that. You can go to equalrightsamendment.org. So let's now focus on the 14th Amendment, because that is that limit on what states can do with the laws that a state can pass to limit the rights of their citizens. So the key provision is, it says that no state shall make or enforce any law which abridges the privilege or immunities of any of its citizens, nor shall the state deprive a person of life, liberty, or property without due process, nor deny to any person the equal protection of the laws. And what that has meant is a lot. That has meant an awful lot to a lot of people. And we're going to focus on some of the ways that 14th Amendment has affected us. And then we're going to talk about the actions that the Supreme Court is taking to go back. The first area we want to talk about is marriage equality. We know that the case of Loving versus Virginia, the Supreme Court found that Virginia laws banning interracial marriage violated the 14th Amendment. And as a result, race-based marriage laws in all states were struck down. And then more recently, in the Obergefell v. Hodges case, the Supreme Court found that same-sex marriage bans are a violation of the 14th Amendment. And as a result, states were required to recognize marriages of same-sex couples on the same terms and conditions as the marriages of opposite-sex couples. And I want to note here that the right to marry is not specifically stated in the Constitution, but it is a fundamental right that's protected by the Constitution. And so the way these cases work is that the Supreme Court says, well, let's see if a right is being affected by a state law, and what kind of right is it? And the Supreme Court says, well, the right that's being affected is the right to be married, and that is a fundamental right. Therefore, we will look and see under the 14th Amendment whether that right is being taken away on an unequal basis or in violation of due process. And so these two cases are examples of how that 14th Amendment protects marriage equality. 14th Amendment, that same type of rationale, also was applied in two cases to a state ban on the use and sale of contraceptives. One was on married couples, one was on unmarried couples. And the court went through that process and said, oh, is there a right here? Then the right they found was a right of privacy, and that right of privacy was a fundamental right protected by the Constitution. And since it was protected by the Constitution, a ban on that right would have to be struck down because it was violating that right of privacy. And the 14th Amendment was used as the conduit to say, well, that's because the 14th Amendment, we're going to protect these rights to contraception under the Constitution. Then we get to Roe v. Wade, and then the Casey case. Those were also cases decided under the 14th Amendment due process clause and the right of privacy. And the court found in two different times, and there are other cases as well, that right of privacy was fundamental, and that it could not be taken away by state law. Then we have the Dobbs case, and the court said, well, no, the 14th Amendment does not provide a right to abortion. A right to abortion is not protected under the Constitution, and therefore it can be regulated by the states. And the theory under which that overturning of Roe v. Wade was argued was what's called the originalism history test. And what that test is, it says, well, you cannot have we can't use a modern interpretation of the 14th Amendment or the Constitution we have to go back and say, what was the understanding literally centuries ago of these rights? And Justice Alito, who wrote the Dobbs opinion, said, well, the Constitution makes no reference to abortion. That is true. And he says it's not implicitly protected by any constitutional provision. And he says, well, it's true that the 14th Amendment would protect some things which are not specifically mentioned. But if it does, that if there's something that we think is a right, it has to be deeply rooted in this nation's history and tradition, which really calls into question all of those other cases, because it is now possible for the Supreme Court to go back and say, well, we were wrong about, in the past, the Supreme Court was wrong about abortion. Maybe they were wrong about marriage equality. Maybe they were wrong about contraception. Alito's solution was, he says, well, I'm going to return the issue of abortion to the states, and women are not without electoral or political power. And so we're going to go back and let the states make the decision. And right now, when Kamala Harris is talking about we're not going back, we're going forward, this is a really, really important example of that, because what the Supreme Court is doing, what is going back and undoing civil rights that we have been granted as through the interpretation of the 14th Amendment. And so when we're talking to our friends and family about voting and why it matters, it's because we don't want to go back. Alito's decision opens the door for federal legislation banning abortion. We know that more than half the states have taken action or are poised to ban or severely limit abortions. And so we know that the most important election is always the next one, because we want to preserve what we have. We don't want to go back. If we're another example of how the 14th Amendment can work is with the Second Amendment, in terms of possessing firearms. And then starting back in 2008, the Supreme Court recognized a right of an individual to possess firearms independent of service in a state militia. And then that was carried through in a case involving the city of Chicago to say that using the 14th Amendment, the Second Amendment applies to state and local governments. The most recent case on this is that I think is very important, is a case in New York State where the Supreme Court, in an opinion written by Justice Thomas, struck down a 100-year-old law in New York that was called the proper cause requirement. Under New York, you had to have proper cause to obtain an unrestricted license to carry a concealed firearm. And the Supreme Court ruled that violates the 14th Amendment, and that there was a right of law-abiding citizens to defend themselves using a weapon. The state legislature immediately passed a new law because they could tell that they needed to be ready based on the arguments before the Supreme Court. And then at the end of last year, that new law, which had been challenged in court, was upheld by the Federal Second Circuit Court of Appeals, upheld most of the provisions of that law. It's still But there could be more challenges coming. There were many important cases that were decided in the current, we call it term, in the current term of the Supreme Court that would be cause for concern. And one of the things you'll note about these cases as we go through them is that how many of them were agreed to by 6 of the 9 justices. The first one that I would put on that list of cause for concern as Trump versus the United States, where Trump was granted, it was ruled that Trump had absolute immunity from criminal prosecution for official actions, and that there was a presumption of immunity from prosecution for all of his acts. There is no immunity for unofficial acts. There was a case involving the January 6th rioters where the Supreme Court threw out one of the charges against a January 6th defendant because they did not think that the crime of obstruction of an official proceeding applied to the rioters. That only applied, they ruled, to evidence tampering. The third one on this list is one that I think will have as big an impact as perhaps any of the others, and that is the overruling of what was called the Chevron deference theory. Chevron deference is again a 40-year-old precedent, which said that administrative agencies were to be given deference in their reasonable interpretation of federal laws. There are so many agencies out there that have the responsibility for implementing and interpreting federal laws. Think of the EPA, think of OSHA, the Securities and Exchange Commission, just that whole number of agencies, the federal agencies, who have adopted regulations, who have interpreted the laws, who have applied the laws under the Chevron deference theory. A court was to give deference in a challenge to an administrative rule. A court was to give deference to the administrative agency's interpretations, and this was overruled. And the Supreme Court said that courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority rather than defer. This has the potential to open the floodgates for businesses to challenge all of the regulations which they find onerous. So that one I would put as a major cause for concern. And then in a case involving South Carolina, the Supreme Court upheld gerrymandered voting maps that were designed to protect a Republican incumbent. And the voting maps were challenged as being racially discriminatory. And the Supreme Court said, oh, no, it wasn't racial discrimination. It was just anti-Democrat discrimination, and that's okay. The Supreme Court has actually been of 2 minds on this. This one is the one that is the cause for concern. There's actually another one which may give us a little cause for hope. More cause for concern. An example of the Supreme Court taking away authority from an administrative agency. There was when Trump was in office, the ATF adopted a rule that a bump stock made a gun into a machine gun, which would be illegal. And the Supreme Court ruled that the the ATF had exceeded its statutory authority. Securities and Exchange Commission tribunals, the Supreme Court found that the SEC cannot continue to handle fraud cases where fines are imposed without a jury. And in the case of the EPA, the Supreme Court temporarily blocked a rule that would have reduced air pollution from power plants in 23 states. The last one on this list is the encampments in public spaces, and the Supreme Court upheld an ordinance that bars camping on public property because they said, well, it's just a ban on public property. It's not a ban on people who are homeless. It's just a ban on camping. And they found there was no violation of the Eighth Amendment ban on cruel and unusual punishment. There are some bright spots. I don't want to leave. The Supreme Court did uphold a funding mechanism for the Consumer Financial Protection Bureau. They did expand the ability to bring employment discrimination lawsuits. They held it in a case involving social media. The Supreme Court held that public officials can be liable for blocking or deleting criticism when acting in an official capacity. And then there was a case involving tribal healthcare expenses, allowing the payment of additional administrative costs of tribal-run healthcare. Some more bright spots. Thank heavens. There was the Supreme Court upheld a law which would remove guns from domestic abusers in the Rahimi case. There was in 2 states, I think Florida and Texas, had put had tried to regulate the large internet platforms. The Supreme Court said you have not those. You need a different analysis, a better analysis under the First Amendment. When the White House was asking for the social media companies to remove misinformation about COVID, that was challenged, and the Supreme Court said, well, the plaintiffs did not have standing to challenge that, and so allowed that to continue. And there was an actual challenge to the Trump tax cuts. This is actually part that would have imposed taxation on certain what they call repatriated income, and that was upheld. And things that I would put somewhere in the middle, and these are my categories. This is no one else's categorization. We know that there was in a state where Trump was kept off the ballot because he was deemed to be an insurrectionist, that was struck down. Trump was allowed to be on the ballot. I put that in the middle because there were different opinions actually that were part of that decision, and I would say that the 6 that are generally writing the more conservative, I guess you call it, positions, really took some extreme points of view in that. So I think we'll see how that will come up. There are 2 cases dealing with abortion that I would keep in the middle. One was the challenge to mifepristone, and that lawsuit. That lawsuit challenging that abortion medication was dismissed on procedural grounds. It was there, so there's still I think there's still a risk there. A challenge from Idaho, trying to balance whether or not an Idaho ban on abortion, how that would would that conflict with federal law, which requires emergency rooms to provide life-saving care? That case was also dismissed on procedural grounds, so we don't know where that's going to end up. And then there was a case that struck down an opioid settlement. And we just have to see whether there will be another settlement that comes out of that. So one of the questions that I think should arise after this is, how do you can we fix the Supreme Court at this point? I mean, we know the Supreme Court, as the majority of the Supreme Court wants to drag us back, and wants to remove business regulation that protects individuals. What can we do to fix that? Well, the number of justices is set by Congress. There's been 9 justices since 1789. So there's a possibility that that could change. We know that that the president nominates the justices and they're approved by the Senate. When President Biden first came into office, this was such a hot topic, and he said, well, I'm going to have a presidential commission look at this. And the presidential commission came back and said, Congress can enlarge the court. If you want term limits, the commission said, we think that takes a constitutional amendment. The commission endorsed an advisory code of ethics, and then suggested changes to the court's management of what's called its shadow or emergency docket. And then at the end of last year, the justices themselves adopted a code of ethics of saying that a justice should uphold the integrity and independence of the judiciary, avoid impropriety, perform the duties fairly, and refrain from political activity. But said a justice may engage in extrajudicial activities consistent with the obligations of the judicial office. But there's no enforcement mechanism in that code of ethics. So what could Congress do? And we know that, again, Congress could pass legislation to increase the number of justices. That Congress could initiate a constitutional amendment. That Congress can change the jurisdiction and procedures of the court, the ultimate is that the Congress can impeach a justice on the Supreme Court and follow the impeachment rules, which would be you have an impeachment in the House and a trial in the Senate. And just very recently, President Biden had a 3-part proposal. The one is he calls it the "No one is above the law" amendment, saying that in that amendment would say that the Constitution does not confer any immunity from federal criminal indictment or prosecution. Biden's number 2 proposal is that there would be term limits for Supreme Court justices, appointing 2 justices every 2 years to spend 18 years in active service. And then his other proposal is that Congress should pass a binding code of ethics. Senator Schumer and numerous other senators introduced the No Kings Act to reaffirm that the presidents and vice presidents do not have immunity. And then it takes additional steps of removing the Supreme Court's appellate jurisdiction for any constitutional challenges of the legislation. And so what can we do? Well, there's a theme here. We can vote. We have to, and this is where we focus ourselves and focus our friends and families and colleagues on the importance of voting and how and what a difference that makes in the Supreme Court and what a difference that makes in how laws are adopted and implemented. And the last bullet point on this slide is, if we can support the organizations that litigate important issues. It costs an actual $1 million, and now it may cost more than $1 million, but it costs an actual $1 million to take a case to the Supreme Court. And there are organizations that are doing that. There are also organizations that are litigating other important issues, and if we can support them. So in the time remaining, we're going to zoom through some parts of the workbook that you all can refer to at other times. And the first thing we're going to review, because these are again I think simple things, but just something for you all to have as a reminder in case you're working with a group, talking to young people, whatever. Just how a bill becomes a law. It's really, as I say, it's 5 easy steps, and this is true at the federal level. It's true at the state level. It's generally true at the local level, where we have a bill that's drafted to be introduced into the legislative body. A committee works on that bill, and then after a committee has worked on that bill, the bill can come out of committee and go to a vote by the chamber, by the House, by the Senate, by the City Council. And then the bill is passed and then can go to the executive for approval. Some terms that we hear, and that the workbook can give you some definitions to refer back to. If we're talking about the U.S. Senate, we hear, I think, very, very often about the filibuster. And the filibuster is a way under the Senate rules to delay action. The effect of, you put the filibuster together with that word cloture, and it comes out to mean that it takes 60 votes out of the 100 in the U.S. Senate for a bill to be considered, for it to be voted on, for it to pass. The exceptions from the filibuster are the reconciliation, and that reconciliation is a term of art at the U.S. Senate. It means any bill or resolution pertaining to revenue, taxes, or the debt limit, and reconciliation, a bill in that arena can be adopted by a majority. It's also true of the appointment of judges and the cabinet members. So those 3 pieces that are there, the filibuster, the cloture, and reconciliation, are 3 critical definitions to understanding how the U.S. Senate works. At the bottom is a quote from a publication by the Congress about what kind of government are we, and we've talked about it so many times. We are a federal, we have 3 levels of government: representative, democratic, republic, where people have the means to control government and people elect our delegates. If we're looking at the U.S. House and Senate, we know we have 100 senators, 2 per state, regardless of population, serving 6-year terms. We go on down to the House of Representatives, 435, and that number is set by federal statute. And again, each state has at least 1, and the total of representatives greater than 1 is based on population or apportionment. And the districts that are represented by those representatives is determined by state legislature. So in Congress, who's up for election this year? Every U.S. representative is up for election. 1/3 of the U.S. senators are up for election. And now's the time, as I'm sure you all are, to check on the views of your senators and representatives and the candidates, and on the issues that are important to you. And we have another course coming up where we'll get tips on writing those elected officials. So let's talk again. We're walking you through the workbook. We have information here. Really it's like what's that called? It's like a glossary. That's what it is. A glossary of terms about elections, different types of elections, the general election, the primary election, and what are the different types of primaries? And so ranked choice voting, that is in the workbook for you to consider. And then some more definitions that may be helpful if you're talking to a group, or you just need something quick to look back to if you're writing a letter. And just one of the things I want to mention here is that over the course of our history, states have become really the focal point for running elections. When we think about that, go back to the beginning, with the federal government having certain responsibilities, and then what are the states' responsibilities? Really, it has ended up that the states are primarily in charge of conducting elections, and in your state, or in Indiana, it's the Secretary of State's office at the state level and the county clerks at the county levels where we find the administration of our elections being housed. At the federal level, we have the Federal Election Committee commission responsible for looking at election financing. And then we do have that 13th Amendment on the voting rights, but the Supreme Court has been moving that backward as well, and giving it less and less applicability. When we're out there talking to family and colleagues and friends and encouraging them to vote, we hear, if you're, my vote just doesn't matter because of gerrymandering. I can vote, but it's not going to make a difference because I'm in Indiana, and in Indiana, we are definitely in competition for being the most gerrymandered state. But just help people keep that in focus, and that is that the issue of gerrymandering is only relevant where there are districts. If we're talking about something that is statewide or citywide or countywide, then there's not gerrymandering there. Our votes count. But even where there is gerrymandering, I believe that our vote always matters, because you want the elected official to know that there are people out there who support that person or don't support that person. We want to avoid the idea of a mandate. I wanted to mention this case is one of the good cases. Maybe I should move it to one of the other slides, but this actually upheld a lower court ruling saying that that Alabama's congressional map likely violates the Voting Rights Act. And so Alabama was required to come up with new maps. But that South Carolina case that I mentioned earlier may give another route that would make this Alabama case not as important as I might hope it would be. One of the things for us when we're thinking about elections is David Pepper in Saving Democracy says that we need to learn from the MAGA election strategy. We should not just focus on federal elections or swing states. We need to pay attention to state elections, state houses, all levels of government in our election. So if you're someone who just, and I know there are folks who just cannot stand to hear anything more about the federal election, and you want to dive into your mayoral election, your township election, do that, because that is where we will be building our bench for the future. Become an expert on upcoming elections in your state. Who is on the ballot? What is the last day to register to vote how do you register to vote? We had a little family gathering on Sunday, and my sister-in-law had her phone out, and she was walking around and making sure everybody was registered to vote, looking up their registration. She was not to be denied, and she did actually register my nephew's son. It actually was very exciting. What is the, if you have mail-in balloting, when's the last day to request it? When's the last day to mail it in? Please just create this little, find that list. The League of Women Voters in your state may have that. Your county clerk may have that you can post on your social media, that you'll have also in your, kind of back pocket, that you can share that information. Because you talking to someone about that is about voting and how to vote is really the most important thing that we can do. We're gonna in the workbook, there's an example, but it's Indiana, where we look at, each state has a constitution, and that constitution follows the federal government structure, establishes 3 branches of government. And then in Indiana, I've given you the example of our legislative branch, our executive branch, our judicial branch. So you all are, maybe already right on top of this, but do yourself a favor and just refresh your recollection, refresh your memory on this, of how many members are in your state house, in terms of your House members, your Senate members. And in Indiana, we are a state where the Republicans have a supermajority in both the House and the Senate, which means that in each house, Republicans can take action without Democrat involvement. Be aware of what the session dates, when is the legislature in session, and also help your friends figure out who is their state representative, who is their state senator. This gives an example of how a bill becomes a law. Again, in your state, it's probably similar, but there may be some variations that you may need to be aware of. And then in terms of the executive branch for this, the state, that's going to be your governor. And one thing to figure out in your state is, what does it take what does it take for a governor to veto legislation? And what does it take for his or her veto to be overridden? Indiana has what's called a weak government system, where if legislation is vetoed by the governor, his veto can be overridden by just a majority vote of both chambers. And then the judicial branch with the Supreme Court, what are your different courts under your state constitution? And then when we talk about kind of who's in charge, going back to that, one of those original slides about whether it's the federal government that's in charge of something or it's the states, we look at historically, what do states do? And they regulate property and education, insurance. There's a list of this developed over time. And then the federal government, because of the Supremacy Clause and the Interstate Commerce Clause, still are in that oversight role of state action. So the homework, prepare that chart of the structure and the office holders in your government, in your state government. Who is your state representative, your state senator, your counselor? And then what are their positions on issues that are important to you? We've pulled out of one of our other workbooks a couple of charts that you can use to help you in that endeavor. And then, think about where you can use the knowledge that you have pulled together for yourself. If you're canvassing, if you're on the phone bank, if you're a poll worker, and I think sometime last week might have been National Poll Worker Day. And if you have not been a poll worker, I really encourage you to do it. It's just wonderful. It's really inspiring, and it's tiring, but it's also wonderful. Be that network resource for your friends and family. And if you have other ideas, share those in the chat and with the folks who are on. And some resources for you. If you want to see what's happening in the Supreme Court, there's the SCOTUS blog. And also any of the cases that are on these slides that you want to know anything about, literally just type the name of the case. You don't need anything special. And SCOTUS blog will pop up and you'll find something there, or you may find something that then takes you to an organization that is interested in that issue. For example, if you're interested in the EPA case, you might go to an environmental organization that would have some more background on that. If you want to know who and what's on the ballot, League of Women Voters. If you want to track legislation, Legiscan. And then I really like the Brennan Center for Justice if we're talking about voting, elections, preserving our democracy.